Well, hello and welcome again. Employment Law Show. So good to have you along for the next 30 minutes. John Scholes here, and joining me in just a moment, Lior Samfiru, employment lawyer, of course, co-founding partner Samfiru Tumarkin LLP. You can reach out to Lior and his team anytime you like. I'll give you that contact information just before we get started on everything. 1-855-821-5900, help@employmentlawyer.ca. And there is a website constructed just for your use. It's absolutely free. It's anonymous. There's all kinds of talking points and education about employment law on there called pocketemploymentlawyer.ca. I know we're going to refer to it probably over the next 30 minutes or so. And within that, which we will definitely go through today, is the severance calculator. That does exactly what the title says. It calculates your severance, what it should be, not the number that you've given by your now ex-employer. This is the real number that you have your rights to getting. That's the severance number you're going to get. And we're going to refer to that today. You can go there anytime and use it for absolutely free, because over 2 million people before you have used the severance calculator. So it's a very trustworthy tool. So have a look at that. Coming up today in the show, Lior, 5 fast facts about wrongful dismissal. This is a topic that yields a lot of confusion, so we'll clean that up and get to that in just a little bit. Some phone calls from one of our radio shows across the country and some other emails and talking points as well. But, brother, we always start off with the week that was. How are you?
I am great and always ready and pumped to be here to talk about employment law. I consider this, John, a privilege to be here, to have the opportunity to educate people and inform them about their workplace rights. I get emails all the time from people telling me I've learned something about my rights that I didn't know before. You've helped me understand my situation. That's exactly why I'm here, why we're doing this show and have been for years. It's about you knowing what your rights are, and you knowing how to deal with the workplace problem. So you're not left out in the cold, you're not intimidated if a problem arises. You'll know what to do, you'll know what to say, you'll know where to turn to if you need help. I speak every day with people that have either lost their jobs or been given an ultimatum, or people that are not treated properly at work, or their job has changed. So if you're in that situation or anything else to do with your employment law rights, give me a call and let's connect about it. Let's talk about it, and let's make sure that you have the help and support that you need. We'll give you the contact information throughout the show today if you want to reach out. But right now, let me tell you about a situation that came across my desk. Now, I know, John, you've heard me refer to the fact that before that often people call me with the wrong questions, at least not the questions that they should be asking. And I got the example of that this week. A lady called me because she lost her job, and over the weeks since losing her job, she's been trying to get her record of employment from her employer. She needed it, of course, to apply for EI, and her employer was ignoring her. They weren't getting back to her. They weren't sending her the record of employment. And she was frustrated and mad, of course, because she's not getting it. She wants that EI. So she did the right thing, of course. She called me. And she wanted to know, Lior, how do I get my EI, my record of employment so I can apply for EI? And obviously that's an important issue, and the answer is very simple. I can easily get that for her. But as soon as I heard that she had lost her job, I asked her a few more questions. Now, she had been with this employer for 6 years. She was paid 6 weeks of severance by this employer. Didn't think anything of it. The money had already been deposited, and simply wanted her record of employment. Except when I talked to her, I assessed her as being owed probably 8 or 9 months of severance, not the 6 weeks that she was paid. So she was owed another half year of pay here. She didn't realize this. She was concerned about the record of employment, but she didn't actually realize that what she should be concerned about, even more so, what she really should be calling me about, is the fact that she was actually wrongfully dismissed. She is owed a lot more severance than she was paid. Very common situation, by the way, where people call me because they're concerned about overtime or vacation pay. All legitimate questions, don't get me wrong, but there's often a bigger issue that they should be concerned about. She was extremely surprised to learn that she's owed another 6 months of severance or so. I'm helping her get it now. It's not going to be a problem. I'm so grateful and happy that she called me about that record of employment issue, because now I'm going to be able to help her get her full severance. So very much with you as well at home. You may not realize the extent of your entitlements. You may think that you have minimal entitlements, or that the real issue is one thing, when in fact it could be something else. That's why it's so vitally important that you call, your email, if you're facing a workplace problem. If you're not sure what your rights are, ask the question. You may find out and be surprised to learn what your real rights are.
Well, let's talk about that 6 weeks. I mean, she got that money. She was like, okay, whatever about that. I want my ROE. But that 6 weeks, the reason she didn't bat an eye is because that's a very common belief. Yeah, I worked for 6 years, 6 weeks, week per year. We're good to go, right?
That's exactly right. One of the most commonly held beliefs, and by the way, which are completely wrong, that you get a week per year of service. You know, one day, John, you and I are going to take our show down on the road there, and we're going to take a microphone and a cameraman. We're going to ask some people on the street, hey, how much severance do you get if you lose your job? I bet you when we do that, we'll find out most people are saying, oh, it's a week per year of service. All of that, of course, is wrong. Your severance is a lot more than that. It could be months and months and months, up to 24 months of severance. So yes, I'm glad she called. She was under the misbelief that many people have the same. So it's not a week per year of service. You want to get your full entitlements, always happy to talk to you.
Now, again, it's very easy for Lior to do that because, you know, you can do it inside your head in about a moment, but that's why we mentioned pocketemploymentlawyer.ca. You can go there anytime. Severance calculator available at pocketemploymentlawyer.ca, and you can do exactly what Lior did in about 30 seconds and figure how much severance you are actually owed as well. You can also go to employmentlawyer.ca. There, if you search around a bit, you'll find the media tab, and you'll find a radio show somewhere across the country close to you, and you can catch our weekly radio show. It's been almost 10 years we've been doing that. They're about an hour long in some jurisdictions, so lots to learn there as well. We pull some calls that we get on the shows each week. We play them back here, Lior, and we talk about them. Let's get to our first call for this week.
The company that I've worked for 15 years has made a decision to move, decided to go and opt for the severance package. And so they came back with an offer, and I just wondered if it was fair.
You were there for 15 years. What kind of a job? What were you doing there?
They called me the Eastern DC manager.
How old are you?
I'm 62.
What was their offer?
They offered me 12 months.
And what's your salary?
It's around the six-figure one.
Wow.
So I said right before this call that most people believe that when you lose your job, you get 1 week's pay per year of service.
Yep.
I told you that's completely wrong. But I bet you if we asked most people and they said, well, this guy got 12 months after 15 years, so he got not quite a month per year, but close to it. Is that good? Most people, in fact, will tell you, wow, that's a great deal because it's a lot more than a per year of service. Wrong. It's not a good offer. This guy, even getting 12 months, is certainly owed more. There's a number of factors here that go to increase the amount of severance that he's owed. Number one, 15 years certainly is a long time. He's in a senior role, in a managerial role with a six-figure salary. He's also older. He's 62 years old. All those are factors that increase severance. So, of course, the real question becomes, they offered him 12 months. How much is he actually owed by way of severance? I can tell you, but let me show you. We're going to go use our severance calculator. John mentioned it before. You can find it at pocketemploymentlawyer.ca. And let's see how much severance this guy is actually owed. So we know that he's been there for 15 years. You see that on the screen. He's a manager making good salary. He's 62 years of age. He's offered 12 months. Except you see right on the bottom of your screen right now, he's owed 18 to 20 months of severance. So that's, 6 to 8 months more than what he was offered. He makes six figures. Well, that's going to be a substantial difference. So even in a situation where someone gets a lot more than a week per year, they're still likely owed a lot more severance, just like this person. So bottom line, whether you work for 15 years or 5 months, whether you're senior position or junior position, young or old, give me a call. You'd be surprised by exactly how much you're owed.
And it's not always just the dollars that come through in that severance for that 18 to 20 months, right? I mean, there's also the whole components of any bonuses, any car allowance, any benefits, any coverage in that regard. Does that not have to be part of that package too?
Absolutely. So it's not just the salary that's included. Your severance has to include all components of your compensation. Benefits is always a big one. You want to have benefit coverage for you and your family. And the company has to continue your benefit coverage for the severance period. If the severance period is 20 months, they have to continue it for 20 months. They also have to pay whatever bonuses you would expect to earn. If you have a car allowance, they have to continue that. Stock options, those have to be accounted for. Everything has to be included, not just your salary. Very important to remember that.
Want to mention as well, both on Facebook and YouTube, Lior does a ton of live streams during the week. You can always catch those. Simply go to @STLawyers, @STLawyers to join that particular party. There's always questions being asked as well. I want to get to one before we get into a break here, Lior. Again, Facebook and YouTube, live streaming @STLawyers. How do you proceed with a harassment complaint within the workplace if the source of the abuse is a superior. It's your boss.
It is your boss, and it's going to be very complicated and even frightening sometimes to deal with that. But here's what I say. If there is a dedicated person in your workplace, an HR person, someone else, employee relations person, talk to them, the owner of the company, someone above your direct supervisor, again, either HR or someone more senior, let them know in writing about the harassment. And the reason you should feel comfortable doing that is you are not allowed by law to be punished. You can never, ever be punished for complaining about harassment. That's completely illegal. So feel empowered to do that. Now, if you try to do that and nothing happened, or there's no one to talk to because the person harassing you is the owner, who are you going to talk to? Then talk to me. Okay, we need to deal with it externally. I can deal with it for you. I can also get you out of there with compensation, of course. But always, if you can, try to speak to someone, put it in writing, turn the onus on the company to investigate and rectify that. Then if you need to, call me.
And there's a bit of an alarm bell in that regard when it comes to your employer or those who you should be reporting to. They can't ignore this, can they? Legally, they can't ignore it.
It is completely illegal to ignore a harassment complaint. You have to, number one, take it seriously. It starts with the employer taking it seriously. Then they have to investigate. They have to conduct a proper, thorough, and unbiased investigation, even if it means bringing in an outside investigator. And finally, of course, they have to rectify the problem. And that's not because it's the right thing to do. It is. But it's the legally required thing to do. An employer that doesn't do what I just said is breaking the law, and there are going to be consequences for that.
Lots more to come here. We'll take a break. 5 fast facts about wrongful dismissal. We'll dip into that after break. In the meantime, 1-855-821-5900 to reach out to Lior anytime and help@employmentlawyer.ca. We'll continue Employment Law Show. Stick around. People think you should go to the government to get severance pay. EmploymentLawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at EmploymentLawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think their employer can make changes to their job. EmploymentLawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. All righty, welcome back. Thanks so much for sticking around through that short break. We are back, Employment Law Show. Reach out to Lior Samfiru right beside me, 1-855-821-5900, help@employmentlawyer.ca. And for any other information you want to know about your rights in employment law, pocket employmentlawyer.ca. That website is free. It's anonymous. It also contains the severance calculator, which we already made reference to and used, and we'll use it again before the half hour is up for sure. But Lior, let's get into this. 5 fast facts about wrongful dismissal. So much confusion about what that term means. So we'll break it down right off the top. Number 1 is a wrongful dismissal does not occur because your employer fired you for a wrong or illegitimate reason, right?
And it's very easy, of course, to think that wrongful dismissal means that they let me go for the wrong reasons or for a reason that's false. And unfortunately, that's not actually what a wrongful dismissal is. That's because an employer is allowed to let you go pretty much for any reason as long as they pay you severance. Now, they can't let you go for a discriminatory reasons. They can't let you go because of your age or your ethnicity or disability. That's illegal. But they can let you go because they want to pay someone else less money, or they want to let you go because they think they can hire their cousin. They can do that. That's not a nice thing to do. It's not right, but legally that can be done. So that's not a wrongful dismissal. Wrongful dismissal ultimately comes down to compensation, to severance. So you've been wrongfully dismissed if you have been let go, and you have not, regardless of the reason, that's a wrongful dismissal. If you've been offered proper severance, even if the reason is one you don't agree with, it is legal in that respect. So keep in mind, it's about that compensation.
Yeah, we often, we joke about that, thinking that, my employer let me go because, I'm wearing a paisley tie. Out you go. Would never happen. It's a completely bizarre thing, but they can actually do that if they want, if they pay the proper compensation. Number 2 of the fast facts about wrongful dismissal, Lior. An employer that fires someone for cause and fails to pay severance is likely a wrongful dismissal. There you go.
Absolutely. Again, we're talking about severance. An employer that lets an employee go because they say, well, you did something wrong, something so bad that it allows you to let you go for cause and without severance. If the employer gets that wrong, which they often do, most of the time they do, that's a wrongful dismissal. Remember, it's very difficult to let someone go for cause without severance. It's not enough to show that the employee did something wrong or even a few things wrong. That employee would have to be guilty of very significant misconduct that was repeated. They would have had to receive advance warnings, and only then can they be let go without severance. And in most cases, what I see when a company says, we have cause, we're letting you go, that's a wrongful dismissal. They're let go without severance when they should be paying severance. And remember, even if you did something wrong, as long as it doesn't rise to the level of cause, you have to get paid your full severance. There's no such thing as a discount. So because of that, most cases, when you've been told you've been let go for cause, yeah, you've been actually wrongfully dismissed.
Yeah, it's interesting, but it's very common. I mean, we've had calls where people, I had the company truck and I backed it into the loading dock by mistake, caused some damage, and out you go. They are fired right away for cause, wrongful dismissal. It doesn't rise to the level. It's not the capital punishment, as you would say, right?
Absolutely. Listen, if the person set out to deliberately damage the truck, to damage their employer property, well, that's a pretty big deal, of course. And yeah, that person potentially can be let go for cause. But if someone got into an accident, no, and it's a one-time thing, and it's something that it's not something that happens all the time, it's never going to be cause. So if the company does insist on letting that person go, they still have to pay them their full severance. Unfortunately, oftentimes companies don't. That's where I get involved to make sure that they actually end up paying it.
We're running through 5 fast facts about wrongful dismissal. Number 3, Lior, is this changing the fundamental terms of an employee's job without consent can lead to a wrongful dismissal?
So we've talked about this term before. We call it constructive dismissal. And that is the idea that an employer does not have a right to make significant changes to the terms of your employment. Your employer can't just reduce your pay. Your employer can't just relocate you to wherever they want. They can't demote you, change your hours of work, your shifts. And if they do that, that may give you the right to look at that and treat it as a constructive dismissal. A constructive dismissal is a type of wrongful dismissal. If you've been constructively dismissed, or if your employer did something to change your job, you're owed severance because they haven't paid that severance. That's a wrongful dismissal. So anytime you're facing a significant change, you may have that option to say, that's a constructive dismissal, now I am owed my severance. It's very important to remember that it's not every single change that results in a constructive dismissal. Some minor changes may not rise to that level. That's why it's very important that you consult with me before you say, that's it, I'm out of here. We need to do this right. We need to make sure that we're on solid footings. But yes, a very common type of wrongful dismissal is a constructive dismissal.
Number 4 is this is where it comes down to the timeline. You have 2 years to take action if you are wrongfully dismissed. 2 years.
Yeah, and it seems like a long time, but if you don't know your rights, that time may fly by. Every single week, John, I speak with people that heard me on TV or on radio or online, and they realize, oh, wait a second, I have entitlements. Well, they let me go 3.5 years ago. Can I do something about it? Unfortunately, the answer is no. There's a 2-year limitation period, and there's no wiggle room in that, really. It's not, well, kind of 2 years or, around there. It's a solid 2 years and no more. So very important that if you lost your job, get advice, okay? Not later, not down the road. Do it now. Make sure you do it when you have plenty of time. That also reminds me, though, the flip side of that is this. If you're facing a severance offer deadline, right? Your employer says you have to sign this offer by 5 p.m. on Friday. That's nonsense because your rights, as I just said, don't expire for 2 years. They don't expire on Friday. So it's irrelevant. That deadline is meaningless. So don't stress out over it. Get advice if you lose your job, but don't wait too long.
All right, wrongful dismissal. Fact number 5, as we get this wrapped up, Lior, employees that have been wrongfully dismissed can, and more importantly, should pursue their legal rights.
So Oftentimes I hear from people saying, well, I thought about calling you, Lior, when I lost my job, but I thought it's going to be so difficult to get what I'm owed. It's a long process. It's probably very costly. I just don't want that in my life. So here's the thing. When it comes to employment law disputes, very often, most often, it's not complicated. It's not long. It's not expensive. We can resolve it usually quickly within a few weeks, often without even legal action. And in terms of cost, it's not costly. There's contingency arrangements. So you should never, ever be afraid of the process. There's other legal proceedings that can be very expensive and very long. That's not true when it comes to employment law. So yes, you should pursue your rights. You should at least find out what those rights are. Don't walk away from those.
Yeah, everybody assumes, oh, we're going to end up in court if I stand up for my rights. And it rarely happens, if ever, right?
It rarely happens. It's not necessary, and it's something that we try to avoid at all costs. And usually, it's not even a point of discussion. We resolve it very quickly and on good terms.
EmploymentLawyer.ca. There's a website you can go to find a radio station across the country close to your listening realm, so you can tune into the show every week. In fact, we encourage you during the shows to call in and ask your questions as well. I want to take one of the phone calls from one of our radio shows, Lior, and talk about it right now.
Changed jobs in the beginning of the year. When I was there after 3 or 4 months, they asked me to sign a contract. And stated in the contract, they said they can fire us at the end of a certain period of time if they feel that we weren't successful enough in doing the job that we were supposed to be doing. So I don't understand. Can they do that?
So our regular viewers would have heard me say that if you're already working for a company and now your employer wants you to sign a new employment agreement, that's bad news for the employee, because there's always going to be something in that document that's bad for you. Now, there's probably a bunch of things in that agreement that are bad for the employee. Something that limits her severance, that gives the company the right to change her job, to put her on a temporary layoff. Those are just a few common things that you may see in a new employment agreement. So bottom line is this. Don't sign it, okay? Or at least send me a copy. Let me see what it says, and let me tell you if it's something that you should be concerned about. Don't just sign that agreement. You may find later that you gave up rights. So the question is not, can they do that? The question is, do you have to sign? And the answer is no, you don't have to sign. You can't be punished for not signing. And why would you simply voluntarily agree to give up rights that you have? It's okay to say, no, I'm comfortable with the agreement we have in place, so thanks, but no thanks. Most of the time, that should be the answer.
If they do send it to you, Lior, you look it over, okay, it's okay, they can sign it, it has your blessing. If they do sign it, do they not have to get something for it to make it legally binding?
Yeah, if we look at it from an even next level standpoint, to actually have that agreement be enforceable for the employer, they have to give the employee something in return for signing. Right. Just putting your signature on a piece of paper, if you're not getting anything, is not valid, doesn't make it valid. A signing bonus, a pay increase, extra vacation, etc. If you get something, it makes it valid. But always a good advice, despite what I just said, if you don't want to be bound by something, don't sign it. Best advice.
Yeah. Quick break, back with more, so stick around. In the meantime, number 1-855-821-5900. Email is help@employmentlawyer.ca. This is the Employment Law Show. People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you, they may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca. All right, welcome back. A few minutes to go here, Employment Law Show. I want to remind you, Lior Samfiru, my co-host here, co-founding partner, Samfiru Tumarkin LLP, the most positively reviewed law firm across the country. You can reach out anytime you would like, have a chat. He's got a great team, lots of lawyers with him as well, can help you surely. 1-855-821-5900, help@employmentlawyer.ca, and just employmentlawyer.ca. The website is where you'll find links to our long-running radio shows pretty much across the country. Lior, phone call number 2 from one of our radio shows is coming up now.
Over 25 years with a company, like contract work, my mechanical engineer, but then they just let me go. But they said they don't really owe me anything because I'm a contractor. They wanted me to sign something. They give me $5,000. So should I sign that, or what should I do?
Were you working just full time for them?
Yeah, 45 hours a week.
Oh, and how old are you?
I'm 50.
Wow.
Yeah, well,
how generous.
John, in an upcoming show, we're going to be talking specifically about being a contractor and what that means and how people are misclassified. But what I'll say for now is this. Clearly, this person is an employee in the eyes of the law. You don't work somewhere for 25 years at 45 hours a week and not be an employee. It doesn't matter what they call him, what they think he is, what he thinks he is. The law makes that determination, and he is an employee. Why is that important? It's important because now that he lost his job, he is owed severance, because employees are owed severance. Now, if he was truly a contractor, he may not have been owed severance, but he's an employee that's been misclassified. Chances are, by the way, if you're not sure about your status, you're probably an employee at home as well. So he's misclassified. He is owed severance. It's going to be a substantial amount after 25 years. So let's go to our severance calculator. You can find that, of course, at pocketemploymentlawyer.ca. Again, pocketemploymentlawyer.ca. Let's plug his information into that severance calculator and see what he's actually owed after 25 years of service at this employer. So again, 25 years of service, a mechanical engineer, age of 50. Yeah, they said, yeah, we'll give you $5,000 because we're nice. Well, you see on the screen, he's actually owed as much as 2 years' pay. 2 years' pay at a salary of $70,000 a year. That's $140,000, not $5,000, $140,000. So I think you understand now why it's so important to get this right, the issue of whether you're an employee or a contractor. And by the way, if you're not sure if you're an employee or a contractor, again, the same place you can go to find out right now, pocketemploymentlawyer.ca. We have a tool there that allows you to get an assessment of whether you're an employee or contractor. You want to get it right because just like this person, you may have significant entitlement.
They were a little shy in the severance there, of 5,000 compared to 140. But I mean, he's aware of that now because of you and because of us and because of showing the severance calculator. But what are the pitfalls of not saying, you know what, Lior, I'm okay with being a contractor. The boss agrees, I agree, we're all good.
Well, number one is you give up your rights to employment law rights, overtime, vacation pay, severance. That's a problem. The other problem is what happens when CRA one day knocks on the door and wants to reassess you. And they realize, wait a second, you were actually an employee. You've been filing your taxes like a contractor. They don't have much of a sense of humor at the CRA. So they're going to be making you pay some back taxes, fines, penalties. So you really want to get this right and not try to pretend to be something that you're clearly not.
So it makes no difference if I've been signing contracts every year with my employer. We both agreed. I have it on paper, Lior. I've been doing this for 15 years.
So I often have companies, when I call them on the fact, when they let someone go and they say, this person is really an employee. You're calling them a contractor, but they're an employee. They say, Lior, you must not know how to read. I know you went to law school. Clearly, they didn't teach you how to read. Look at this piece of paper that says contractor. What don't you understand about that piece of paper? And they think that that piece of paper matters. It doesn't matter. If it was that simple, anyone can be a contractor. You just sign a piece of paper that says it, and there you go. You're a contractor. It does not matter. What matters is the relationship you have with the company that you work for. Do you work for them exclusively? Do you work for others? Are you running a business? Are you not? Do you work from the office at home? All those are factors, not what you sign. And that's why oftentimes people are misclassified, John.
We are going to do a complete show on this topic in the future, very near future, guaranteed. In the meantime, here's how you reach out now that we're done for the show today. 1-855-821-5900. That's the number. Email is help@employmentlawyer.ca. And that website, always go there first, pocketemploymentlawyer.ca as well. You get the severance calculator there as well. We'll catch you next time. Employment Law Show.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.